Kansas City, Missouri. January 1979. In a fabricator's shop, somebody redraws one detail on a hotel walkway. One long steel rod becomes two shorter ones, 4 inches apart. Nobody has ever established whose hand drew it. 2 walkways will hang from that detail over a crowded room. On the drawing, it looks like the same thing. That detail is a nut, a washer, and a hole through a steel beam. It does not get weaker when the second rod arrives. It is simply asked to carry twice as much. The Hyatt Regency Hotel in Kansas City had been open about a year. At its center was an atrium, a room roughly 117 feet by 145 and 50 feet high. 3 suspended walkways spanned it at the 2nd, 3rd, and 4th floor levels. They were bridges with nothing underneath them. No columns, no piers, no arch. Steel rods coming down out of the roof and the walkway hanging on the rods. So the whole question in this building, from the day it was drawn, is a small one. What holds the rod? 2 of the 3 were stacked. The 2nd floor walkway was suspended from the 4th floor walkway, which was directly above it. The 3rd was offset from the other 2 and hung on its own rods from the roof framing. Remember that one? It is the reason the 3rd walkway is still standing at the end of this film. Each walkway was 4 spans of steel stringers. Underneath the stringers ran a pair of box beams, and the box beams were what the rods actually held. A box beam sounds like a solid thing. It was not. It was 2 ordinary 8-inch steel channels, laid facing each other and joined toe-to-toe by continuous longitudinal wells. A hollow rectangle closed along 2 seams. The rods were 1.25 inches across, threaded top and bottom to take a nut and a washer. That is the whole connection. A rod through a hole, a washer under the beam, a nut under the washer. There is nothing else in it. As it was first drawn, 1 rod ran the whole way down, out of the roof framing, through the 4th floor box beam, and on down through the 2nd. Each beam sat on its own nut on the same rod, and each beam put only its own share into the steel. The Missouri Court of Appeals calls it, plainly, a 1-rod design. 6 rods, 3 down each side of the atrium, 30 feet of threaded steel apiece. Now the arithmetic, because this film is arithmetic. The project specified a design live load of 100 pounds per square foot for hotel corridors and lobby areas, and the federal investigators read that as covering the walkways. Engineers write that load in kips. A kip is 1,000 pounds of force. It is not a mysterious unit. It is a weight written short. Under the 1-rod design, the load arriving at each connection, at the 2nd floor and at the 4th, would have been about 20.3 kips. The same at both levels because each beam carried only itself. Steel design in Kansas City ran on the AISC specification. That is what the city's building code pointed at for structural steel. Under that specification, a connection carries a factor of safety. The lowest that would govern any part of this one is 1.67. Multiply the design load by that, and you have the load the finished connection is expected to survive before it lets go. For the 1-rod design, that is 33.9 kips. The connection as drawn could take about 20.5, 60% of what the code expected. That percentage is the federal report's own. So the detail was already illegal before anybody changed it. The Missouri Board's tribunal found that the hanger rods and the connections shown on the structural drawings did not meet the design specifications of the Kansas City Building Code, and that finding was not contested on appeal. The federal report reached it separately from the steel. There is one more thing about that drawing, and it is not a small one. The connection had no calculations behind it that anybody has ever seen. Not the federal investigators, not the office of the mayor. Efforts to obtain copies of the structural design calculations, the report says, were unsuccessful. A tribunal would later find that these were special connections and that all connections are the responsibility of the structural engineer. And it found something harder than special. It found them non-redundant. A non-redundant connection which fails will cause collapse of the structure, 6 of them over a room that held 2,000 people. Nothing behind any of them if one let go. Construction was underway while the design was still being finished. The Hyatt was a fast-track project, which means the building went up while the drawings were still being drawn. The steel fabricator was Havens Steel Company. Havens had engineers of its own, capable of designing simple, complex, or special connections. Because of certain fabricating problems, Havens proposed a double rod system to the project engineer. Two explanations have been proposed in the literature for why. One is that rods long enough could not be got. The other is that threading a 30-foot rod along its whole length was judged impractical. Both are proposals. Neither is a finding of any tribunal, and this film does not choose between them. Here is what the change did. Instead of one rod carrying two beams at two different heights, there were now two rods. An upper set from the fourth floor box beams to the roof framing. A lower set from the second floor box beams up to the fourth. The second rod did not pass through the same hole. It was offset 4 inches along the beam. Follow the load. Under the new arrangement, all of the second floor walkway load was first transferred to the fourth floor box beams. Then that load and the fourth floor walkway's own load both went out through the fourth floor connections into the ceiling rods. The second floor connection did not change at all. It still carried about 20.3 kips. The fourth floor connection went to about 40.7. The word the federal report uses is doubled, and it uses it as a conclusion. The change in hanger rod arrangement from a continuous rod to interrupted rods essentially doubled the load to be transferred by the fourth floor connections. The Missouri Court of Appeals says the same thing in its own words out of its own record. The effect of this change was to double the load on the fourth floor walkway and on the connections there. No steel was removed. No steel was thinned. One beam was simply asked to carry two. The change was transmitted to the project engineer, and it was approved. There was evidence, the court found, that one of the architects contacted the project engineer to verify that the double rod arrangement was structurally sound and was advised that it was. On appeal, the engineers disputed that. The court reviewed the record and rejected the dispute. It is a reasonable inference from the evidence, the same court wrote, that the engineering calculations and tests necessary to determine whether the double rod design was sound were never made. Somebody did notice. A technician checking the shop drawings called the project engineer's attention to questions about the strength of the rods and about the change from one rod to two. He was told that the change to two rods was basically the same as the one rod concept. Basically the same as the one rod concept. And by the licensing board's own investigation, as reported in the American Society of Civil Engineers Journal, the project engineer had been asked about the implications of the design change on at least 6 separate occasions during construction, and assured each inquirer that the change would not compromise the safety of the walkways. 6 times. Nobody who asked was answered with a calculation because there was not one to give them. The drawings had a hole in them as well. Information about loads and about the connections had appeared on the project engineer's preliminary sketches. It was not carried onto the final structural drawings that went to the fabricator. So Havens had a drawing, Sheet S4 05.1, Sections 10 and 11, and the tribunal that later read that sheet found 2 things about it at once. It did not communicate to the fabricator that the fabricator was to design the connection. And it did communicate to the fabricator that those connections had already been designed by the engineer. The project engineer testified that he intended the fabricator to design the connections. Havens prepared its shop drawings on the basis that the connections shown on the design drawings had been designed by the structural engineer. Each believed the other had done it. Havens sent its shop drawings back for review. As indicated by their stamps, they were reviewed by the contractor, by the structural engineer, and by the architect. 3 stamps. The drawing did not change. The engineering firm had a written procedure for exactly the situation. The commission found, and the engineers did not dispute, that its own internal procedures called for a detailed check of all special connections. That check did not happen. The project engineer did not review the 4th floor connection shown on the shop drawings and did not, in accord with usual engineering practice, assemble its components to determine what the connection looked like in detail. Listen to that last part again, because the film is about to do it for him. No review was made and no calculations were performed to determine whether the connections shown on the shop drawings met code requirements. Both engineers approved the shop drawings. Under the contract and under the statute, review and approval of shop drawings is an engineering function. In October 1979, with the hotel still going up, the atrium roof collapsed. The investigation into that collapse established that the cause was poor construction workmanship. There were 2 accidents at the Hyatt that month, and one of them killed a man. The Federal Occupational Safety Agency investigated a fatal construction accident at the hotel in October 1979. So 21 months before anybody died in that room, the building had already dropped something. The owner and the architect paid the engineering firm an additional fee to go back and check the atrium. The senior engineer assured the owner's representative that he would personally look at every connection in the hotel. In their report to the architects, the engineers wrote, "We then checked the suspended bridges and found them to be satisfactory." They had not. The court found that they did not do a complete check of the design of all steel in the atrium, nor a complete check of the suspended bridges. What they had checked was the roof steel. This is the most damning date in the whole file, and it is worth being exact about why. It comes after the change. It comes before anybody died, and it is a check somebody was paid to make and reported as made. The atrium was inspected, and the walkways went on hanging from a connection nobody had ever calculated. Then the hotel opened, and by the following summer, it had been in service about a year. For about a year, the building worked. That is the part of this that is hardest to keep hold of. 2 walkways carried people across that room every day for a year on a connection nobody had ever calculated. Friday, the 17th of July, 81. Kansas City is hot. Between 1,500 and 2,000 area residents chose to escape the heat at the hotel's tea dance, a weekly event with big band music and a dance contest. They began arriving in the middle of the afternoon. They are not in this film. A television crew was in that room with a camera that evening, and there are newspaper photographs from the hours after it, and none of it appears here. It belongs to other people, and it is a picture of a mass casualty event with survivors still living. What this film has instead is the room empty at 3 o'clock, at 4:30, and at 7. The federal report built a timeline of that evening out of the 2 Kansas City newspapers and printed it in its own pages. What follows is that timeline in its words. 7 o'clock. Crowd in atrium area is estimated at 1,500 to 2,000. 4 minutes passed. Band returns from break and begins to play for the dance contest. 5 minutes past 7. A non-redundant connection gives nothing away first. There is no second path for the load to take. No bend, no sag, no interval. The washer comes through the beam, and the walkway is already falling. The 2nd and 4th floor walkways fell to the atrium floor, and the 4th floor walkway came to rest on top of the lower one. Most of those killed or injured were either on the 1st floor level of the atrium or on the 2nd floor walkway. The 3rd floor walkway was not involved. The 2 walkways together weighed 142,000 pounds. That figure is the Missouri Court of Appeals. About 71 tons of steel and concrete from 4 stories up. What happened after that is in the same timeline, and this film will not show it. It will read it. 3 minutes past the collapse, the first call for help. 14 minutes later, a call goes out for cutting tools. 4 minutes after that, for a forklift. By 52 minutes past 7, there are more than 100 firefighters in the building. At 8:30, a heavy crane arrives. At 3:15 the following morning, the first walkway span is lifted. At 4:30, the last survivor is removed from the debris. 9 hours and 25 minutes. The federal report gives it 11 lines. 114 people died. At least 186 were injured. The federal report, and the engineering literature after it, use the same phrase for what that was. The most devastating structural collapse ever to take place in the United States. This film names none of the dead. Neither the federal report nor the court names one, so there is nothing here to leave out. What there is a number in a room that had been full at 7:05. On the 20th of July, 3 days after, Senator Thomas Eagleton's office contacted the National Bureau of Standards and requested that technical assistance be provided to Kansas City. 2 days later, the mayor formally requested that the Bureau independently ascertain the most probable cause of the collapse. 2 senators and a congressman endorsed the request. The Bureau's people did not get a free hand. In the early phases of the investigation, their involvement was limited by court order to visual and photographic observations and measurements. Permission to weigh the spans and to cut specimens out of them came later, by court order, after the parties in the litigation agreed to it. What came out of it in May 1982 was Building Science Series 143. It is a National Bureau of Standards document, not a National Institute of Standards and Technology 1. The Bureau did not become the institute until 1988, and everything in this act is read out of it. Its first conclusion is the one nobody expects. Collapse of the walkways occurred under the action of loads that were substantially less than the design load specified by the Kansas City Building Code. Less, not more. The most probable cause, it concluded, was insufficient load capacity of the box beam hanger rod connections. Two factors contributed: the inadequacy of the original design for the connection, which was identical for all three walkways, and the change in hanger rod arrangement during construction, which essentially doubled the load at the fourth floor. Now the four numbers, and they are the argument. As drawn, the connection had to carry 20.3 kips. As built, the fourth floor connection had to carry 40.7. At 40.7, with a factor of safety of 1.67, the code expected that connection to survive an ultimate load of at least 68 kips. So the Bureau built the connection again and pulled it apart. Across its test series, the estimated mean ultimate capacities of the fourth floor connections range from 18.2 kips to 19.3, with an average of 18.6. 68 required, 18.6 available. Then the last number. It is the one this case is quoted wrongly on more than any other. The maximum load actually acting on a fourth floor connection at the moment of collapse was about 21.4 kips. The Bureau puts it as a percentage. The maximum load on a fourth floor connection at the time of collapse was only 31% of the ultimate capacity expected of a connection designed under the Kansas City Building Code. That 31% is a load. It is not a strength. It says how much was on the connection, measured against how much the code wanted the connection to hold. The strength ratio is a different number, and the federal report never states it. 18.6 against 68 is about 27%, and that figure is ours, not theirs. Measured the other way, against the design load rather than the ultimate capacity, the load on the night was 53% of what the code required for design. About half of the paper load on a Friday evening. The report is just as firm about what did not do it. Neither the quality of workmanship nor the materials used in the walkway system played a significant role in initiating the collapse. And dancing did not do it. Dynamic loads induced by walking or dancing on the walkways would not have been significant in comparison to the static loads. That is the report's own conclusion, and it kills the story most people have heard about this building. The Bureau counted the people too, as carefully as it could. It concluded that a total of 63 people represents a credible upper bound combined occupancy of the second and fourth floor walkways at the time of collapse. 63 at the outside on two bridges specified for 100 pounds a square foot. The failure appears to have begun at one connection. Observed distortions strongly suggest that it started at the east end of the middle box beam in the fourth floor walkway. It hardly matters which one it was. Each of the 6 fourth floor connections had a high probability of failure. Each was a candidate for initiating the collapse. And failure of any one of them would have led to complete collapse of the walkway system. Here is the hinge of the whole case, and it is the strangest thing in the file. Had the change never been made, the connections would still have been illegal. 60% of code, but they would have held that night. The load actually on a second floor connection at the time of collapse was about 11.5 kips against a single rod capacity of 20.5. An illegal building would have stayed up. The change is what made it lethal. There is an odder fact underneath that one. Because of its greater dead load and design live load, the third floor walkway connection would have had about 53% of the expected ultimate capacity. Had the change not been made, the third floor walkway would have been the most critical of the three. The walkway that survived was the weakest one. Redrawing the fourth floor detail is what moved the failure to the fourth floor. And the third walkway was never safe either. It had, the commission found, a high probability of failure during the life of the building. With the change, the report says, the ultimate capacity of the walkways was so significantly reduced that from the day of construction, they had only minimal capacity to resist their own weight and virtually no capacity to resist additional loads imposed by people. From the day of construction, not from the day of the dance. No one was ever charged with a crime. In December 1983, the county prosecutor and the United States attorney announced that they had found insufficient evidence to convict anyone involved in the Hyatt construction with criminal negligence, and that no criminal charges would be filed. By that date, insurance companies had paid out over $78 million to settle civil lawsuits filed by many of the victims and their families, and no one had yet taken responsibility for the collapse. What happened instead came from a licensing board. In February 1984, the Missouri Board for Architects, Professional Engineers, and Land Surveyors filed a complaint seeking a determination that the certificates of registration of Daniel Duncan and Jack Gillum and the certificate of authority of their firm were subject to discipline. It went to the state's Administrative Hearing Commission, and the commission conducted 27 days of hearing. Its decision runs 442 pages, 98 of findings of fact, 322 of conclusions of law, 180 numbered findings, of which the engineers challenged 5. It was filed on the 15th of November, 1985. The project engineer was found guilty of gross negligence in the preparation and completion of a structural drawing and in failing to review shop drawings of the Hyatt project. He was further found guilty of misconduct in misrepresenting to the architects the safety of a connection when he was ignorant of that safety, due to a failure to perform the engineering tests and calculations that would have determined it. The senior engineer was found vicariously liable and responsible for the acts and omissions of the project engineer, a liability he assumed by affixing his professional engineering seal to the structural drawings. He was further found grossly negligent in failing to review or to assure that somebody had reviewed that drawing before affixing his seal to it. And he was found to have engaged in unprofessional conduct in failing and refusing to take responsibility for the entire engineering project. His answer is in the record in a footnote under cross-examination. Asked whether his seal made him responsible for shop drawings prepared under another engineer's direction, he answered, "Because the shop drawings that were prepared under the direction of another engineer have to be the responsibility of the other engineer. They were not prepared under my direction, and therefore I cannot accept that responsibility." In essence, the court wrote, he placed the responsibility for the improper design of the connections on the fabricator and took the position that the structural engineer was entitled to rely on the fabricator's expertise. The answer to that is a statute. By Section 327.411, the owner of the seal is responsible for the whole engineering project when he places his seal on any plans, unless he expressly disclaims responsibility and specifies the documents he disclaims. The responsibility for the structural integrity and safety of the walkway connections was the project engineer's, and that responsibility was non-delegable. Reliance upon others to perform that duty, the court held, serves as no justification for indifference to it. The administrative law judge put the same idea in one line. While the engineer may properly delegate the work of performing engineering design functions, he cannot delegate the responsibility. Gross negligence had never been defined in a Missouri licensing case before this one. The commission defined it as an act or course of conduct which demonstrates a conscious indifference to a professional duty. The structural engineer's duty, the court wrote, is to determine that the plans he designs or approves will provide structural safety, because if they do not, a strong probability of harm exists. Indifference to the duty is indifference to the harm. And then the finding that separates this from a disaster story. The discipline was not for the deaths. That breach occurred, the court held, at the latest when their design was incorporated into the building with their approval, and they were subject to discipline whether or not any collapse subsequently occurred. It was not any single act either. The Commission's own footnote says it is only after a complete analysis of their overall performance within the system that any judgment of their conduct can be made. The court agreed it is the combination of a series of acts and omissions which created the structurally unsound walkways, And in a footnote of its own, the court concedes the thing that makes this worth 30 minutes. The original inadequacies of the structural drawings might not have been critical if a meaningful review of the shop drawings had occurred. Every person in that chain did something ordinary. A drawing left a detail to the fabricator. A fabricator solved a fabricating problem. An engineer answered a question the way engineers answer questions. 3 parties stamped a drawing. Nothing in the record says that any of them wanted a building to fall. The board revoked all 3 certificates. It carried out the punishment on the 22nd of January 1986, 4.5 years after the walkway collapse, and the 2 Hyatt engineers became the first to lose their licenses for gross negligence. They appealed. On the 26th of January 1988, the Missouri Court of Appeals reversed one finding, a charge of misconduct arising from the atrium design review, which had not been pleaded in the complaint, and in all other respects affirmed the order of the commission and the discipline imposed by the board. The revocation stood. The profession had its own turn. The American Society of Civil Engineers had rewritten its Code of Ethics in 1976, and its first fundamental canon read, "Engineers shall hold paramount the safety, health, and welfare of the public in the performance of their professional duties." The Hyatt was the first real test of that sentence. The Society's Conduct Committee heard the matter in confidence in the summer of 1986, and 2 of its members stood aside, the chair of the Missouri Licensing Board and the man who had led the federal investigation. The committee members concluded unanimously that the senior engineer should be expelled, with no privilege ever to rejoin. The Board of Direction did not do that. It voted to suspend him for 3 years. He then relinquished his membership altogether. The project engineer faced no ethics committee at all. He had never been a member of any national society. 20.3 as drawn, 40.7 as built, 68 as the code required, 18.6 as the steel could actually give. Nothing on that walkway got weaker. 1 beam was asked to carry 2. The 3 walkways were removed. In their place stands a single span, supported not by delicate, graceful rods, but standing on stout, sturdy columns. That description was written in the year 2000, and this film has not been back to check it. The record this film is built on ends with a court of appeals in January 1988. What either engineer has done since, where they are, or what they think about it now, is not any document we retrieved, and this film does not guess. 114 people went to a tea dance and did not come home. The connection that failed was a rod, a washer, a nut, and a hole through a beam. A state board found that responsibility for it could not be handed to anybody else.